Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. DUI Causing Death Lawyers, Chicago, Illinois. Being charged with DUI causing death in Chicago, Illinois is incredibly serious. These cases carry severe felony penalties and an immediate long-term threat to your driving privileges. A conviction or an arrest can trigger license suspension or revocation proceedings that can affect your ability to work, care for your family, and maintain your independence. Because these cases involve both criminal prosecution and administrative driver's license actions, it's critical to have a defense strategy that addresses both fronts from the very beginning. If you're facing DUI causing death charges in Chicago, you need an experienced criminal defense attorney who understands how to fight the criminal allegations while also protecting your driving privileges at every stage of the process. DUI Causing Death Lawyers in Chicago, serving all of Cook County, Illinois. A DUI causing death charge in Chicago or anywhere in Cook County can turn your life upside down. In addition to dealing with the loss of your driving privileges and the ripple effects that come with it, you're also facing aggressive prosecution and the possibility of a lengthy prison sentence. Trying to handle both the criminal case and the administrative license proceedings on your own is a risk you shouldn't take. At Combs Waterkotte, we have 8 decades of combined experience defending clients against the most serious DUI-related charges throughout Cook County. Our team understands how to challenge the prosecution's evidence, from accident reconstruction to chemical testing, while also taking immediate action to protect your driver's license. We approach every case with a strategy tailored to your specific circumstances, working to reduce or dismiss charges whenever possible and preparing every case as if it will go to trial. When your future, freedom, and ability to drive are all on the line, you need a defense team that knows how to handle every aspect of your case. Contact Combs Waterkotte today at 3125-00-HELP or reach out to us online to start building your defense. What is a DUI causing death in Chicago, Illinois? In Chicago, Illinois, there are a few scenarios that can result in a DUI charge. According to Illinois law under 625 ILCS 5/11-501, a driver in Chicago or Cook County can be charged with DUI when they drive with a blood alcohol content of 0.08% or higher. They drive under the influence of alcohol or another intoxicating substance, or both. They drive while under the influence of a controlled substance. They drive with 5 nanograms of THC or more in their system. Causing a death while driving under the influence in Chicago is called aggravated DUI, and it occurs if an individual kills another individual as a result of an accident while driving a car, truck, snowmobile, ATV, or boat. The offense counts when killing a passenger of one's own vehicle, a pedestrian, or someone in another vehicle. In order for the charge to apply, the being under the influence must be the proximate cause, or main cause, of the death. In situations where prosecutors may believe they can't prove that intoxication was the proximate cause of the death, they may charge reckless homicide instead. What are the penalties for a DUI causing death in Chicago, Illinois? Typically, under the Illinois Criminal Code, aggravated DUI is charged as a Class 4 felony. However, DUIs that cause death carry higher-level felony charges. 625 ILCS 5/11-501 D1 F. The section of Illinois' DUI statute that covers DU as causing death says that the offense carries a Class II felony charge. This part of the statute mentions particular prison sentences depending on how many people are killed. DUI resulting in 1 death, 3 to 14 years in prison. DUI resulting in 2 or more deaths, 6 to 28 years in prison. According to 625 ILCS 5/11-501D1D, if an individual is convicted of any DUI and has a previous conviction for involuntary manslaughter, reckless homicide, or a past DUI causing death on their record, they'll be charged with a Class III felony. The statute calls for a prison sentence between 2 and 10 years. What are the driver's license's consequences for a Chicago DUI causing death? When an individual either fails or refuses a blood or breath test after a DUI arrest, they'll receive a statutory summary suspension, a notice letting them know that their license will be suspended within 46 days. Suspension lengths depend on whether the offender failed or refused the test, and whether or not they have any past DUI convictions. First-time offenders who fail a test receive a 6-month driver's license suspension. Multi-time offenders who fail a test receive a 1-year driver's license suspension. First-time offenders who refuse a test receive a 1-year driver's license suspension. Multi-time offenders who refuse a test receive a 3-year driver's license suspension. A statutory summary suspension is just the beginning of an individual's driver's license problems when they cause a DUI death in Chicago or Cook County. While statutory summary suspensions are temporary and can be challenged at a hearing within 90 days of receiving one, a DUI conviction can result in revocation of your driver's license for an indefinite period. Under 625 ILCS 5/6-205, the Illinois Secretary of State's office is required to revoke an individual's license for a DUI causing a death. According to 625 ILCS 5/6-208, when an individual is convicted for a DUI causing death, they must wait a minimum of 2 years after the revocation or 2 years after the end of their prison sentence to reapply for driving privileges. A person's period of license revocation after a DUI causing death typically lasts 10 years or more, and can even last a lifetime if they have prior DUI convictions. During the revocation period, they can apply for restricted driving privileges that allow them to drive in special circumstances, like driving to work, driving themselves or a child to school, driving themselves or a family member to medical appointments, driving to substance abuse treatment classes. To receive restricted driving privileges, a person must petition the Secretary of State, attend a formal hearing, prove they're rehabilitated and are at low risk for another DUI. In most instances, offenders convicted of a DUI causing death in Chicago or Cook County never regain full driving privileges and wind up with restricted driving privileges for the rest of their lives. Criminal defense strategies for a DUI causing death in Chicago, Illinois. While DUI death cases in Chicago and Cook County are very serious, they're not impossible to defend against. At Combs Waterkotte, we have found the following criminal defense strategies to be particularly effective in Chicago DUI causing death cases. Challenging whether the defendant was actually under the influence. A foundational defense in Chicago DUI causing death cases is disputing whether the driver was legally impaired at the time of the crash. Attorneys may challenge breath, blood, or urine test results by questioning calibration, administration procedures, or chain of custody. Medical conditions, rising blood alcohol levels, or improper testing protocols can all create reasonable doubt about whether intoxication actually existed when the incident occurred. arguing lack of proximate cause for the death. Even if impairment is proven, the prosecution must show that the DUI was the proximate cause of the death. A strong defense may argue that another factor, like the victim's actions, poor road conditions, or a third-party driver, actually caused the fatality. If causation is unclear or disputed, the state may fail to meet a critical element required for conviction. Fourth Amendment violations: illegal stop or arrest. Under the Fourth Amendment, Chicago and Cook County drivers are protected from unreasonable searches and seizures. If law enforcement lacked probable cause to initiate the traffic stop or arrest, any evidence obtained afterward, including chemical test results, may be suppressed. Successfully excluding key evidence can significantly weaken the prosecution's case, sometimes leading to reduced charges or even dismissal. Challenging chemical test results. Chemical testing is often central to Chicago DUI prosecutions, but it's not perfect. Defense attorneys may question whether testing equipment was properly maintained, whether the sample was contaminated, or whether procedures were followed correctly. Errors in blood draws, lab analysis, or documentation can all undermine the reliability of results and create reasonable doubt about intoxication levels. Fifth Amendment and improper statements. The Fifth Amendment protects individuals from self-incrimination. If Cook County Police obtained statements without properly advising the defendant of their rights, those statements may be inadmissible. Additionally, coercive interrogation tactics or prolonged questioning can render statements unreliable. Excluding damaging admissions can be a key strategy in defending against serious felony DUI charges. Miranda rights violations. Closely related to Fifth Amendment protections, Miranda violations occur when a suspect is subjected to a police interrogation without being informed of their rights. If law enforcement failed to properly administer Miranda warnings, any resulting statements may be suppressed. In DUI causing death cases, where statements can carry significant weight, this defense can meaningfully impact the prosecution's evidence. Challenging crash reconstruction and forensic evidence. In DUI causing death cases, Cook County prosecutors often rely on accident reconstruction to establish how the crash occurred. The defense may challenge these findings by questioning assumptions, methodologies, or incomplete data. Independent experts can present alternative explanations for the collision, such as mechanical failure or roadway hazards. If reconstruction evidence is unreliable or disputed, it can create reasonable doubt about fault and causation. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.